After my husband died, his mother tried to take everything from me except my daughter. My lawyer urged me to fight. Welcome to my story. Carla Friedel stood in my kitchen 11 days after I buried my husband, pointed at the ceiling, the walls, and the floor beneath her feet, and told me she was taking all of it. The house, Joel's law firm, every bank account, every asset down to the last dollar. Everything, except our 4-year-old daughter, Tessa, because, as she said casually, she hadn't signed up for someone else's child. My name is Miriam Friedel. I'm 31 years old, and until recently, I lived in Covington, Kentucky, a small city across the Ohio River from Cincinnati. It's the kind of place where neighbors wave from their driveways and somehow know what you paid for your home. I married Joel Friedel when I was 24. He was a personal injury attorney who built his own firm from nothing. Well, from his mother's $185,000 loan and about 6,000 hours of his own effort. He began in a small rented office above a flooring store on Madison Avenue, where you could hear customers choosing laminate samples through the floor during client meetings. Within 5 years, he moved into a professional office suite, hired a small team, and was billing more than $600,000 a year. Friedel and Associates. His name was on the door, and his mother never let anyone forget who had paid for that door. Joel died on Thursday evening, March 6th, from cardiac arrest. They found him at his desk, his hand still on his coffee mug. He was 36. I received the call while giving Tessa a bath. I drove to the office with wet sleeves rolled to my elbows and soap still under my nails. By the time I arrived, the paramedics had already stopped. The funeral was the following Wednesday. Carla wore black Chanel sunglasses indoors, the kind that covered half her face so you couldn't tell whether she was grieving or performing. Spencer, Joel's younger brother, stood beside her looking uncomfortable. He was 29, had never kept a job longer than 5 months, and lived in Carla's guest house in Burlington, where his routine mostly involved sleeping late and ordering items online with her credit card. It's important to understand Carla. She wasn't fragile or helpless. She had owned 4 dry cleaning stores across northern Kentucky and built them herself after divorcing Joel's father. She understood business and numbers, or at least she believed she did. In dry cleaning, the math is simple. Clothes come in dirty, clothes go out clean, and cash goes into the register. She applied that same thinking to everything, including a law firm she had never worked in professionally. To her, Joel's practice was just another shop, except instead of pressing shirts, you handled lawsuits, and instead of coins, there was $600,000 a year moving through the accounts. From our first Thanksgiving, she treated me like a temporary phase Joel would eventually move past. I had been a legal secretary when we met, not wealthy, not from a prominent family. Once, she introduced me to her friends as Joel's first wife, while Joel and I were standing right there. So when she arrived in my kitchen that Monday morning, 11 days after the funeral, I shouldn't have been surprised. But grief slows your reactions. You stand there absorbing blows you would normally see coming. Carla walked in wearing a gray blazer, dressed as if for a meeting. Spencer followed behind her, carrying a tape measure. While Carla stood at the kitchen island, explaining that she was reclaiming what her investment had built, Spencer went into the guest room and began measuring the closet. I could hear the tape snapping from the kitchen. I remember thinking, what did he even own that required a closet? His most expensive possession was a gaming chair. Carla presented her argument like a business report. The firm had been built with her money. She had also contributed $30,000 toward the house down payment 7 years earlier, a fact she had repeated ever since. In her view, that made her a partner in everything Joel had built. Now that he was gone, she wanted her investment returned, with interest. The only thing she didn't want was Tessa. She said it plainly, like refusing a side dish. Not the child, just the assets. I stood there holding a cup of coffee that had gone cold and said nothing. Not because I agreed, but because my mind couldn't process losing my husband and being financially attacked in the same month. 2 days later, a certified letter arrived. Axel Mindler, attorney at law. Carla had formally contested Joel's will and filed a creditor claim against his estate for the $185,000 loan. This was no longer a family discussion. It was a legal challenge, and she filed it before the flowers on Joel's grave had even faded. Before we continue, please subscribe and tell me in the comments where you're watching from and what time it is there. I read every message. Thank you for your support. Now back to the story. Carla had moved from kitchen threats to courtroom action within 48 hours. Meanwhile, I was still sleeping in a bed that smelled like my husband's cologne, trying to explain to a 4-year-old why her father wasn't coming home. Axel Mendler was experienced. He based the will contest on the claim that Carla's $185,000 loan qualified as an investment in the firm, giving her a right to its value. He also filed a separate creditor claim for repayment of the loan. 2 legal actions at the same time. Carla was paying him $350 an hour and expected quick results, but she didn't want to wait for the court process. The week after filing, she drove to Friedel and Associates, the second-floor office on Scott Boulevard, walked in confidently, and began introducing herself to the staff. There were only 4 employees, 2 paralegals, a receptionist, and Gail Horvath, the bookkeeper who had worked with Joel for 6 years. Carla informed them that she was taking operational oversight and that changes would follow. She instructed Gail to print the firm's revenue reports for the past 3 years. Gail printed them. Carla looked at the top line, $620,000 in annual billings, nodded as if it confirmed what she already believed, and left. She never asked for expense reports. She never asked about liabilities. She didn't open a single folder that wasn't labeled income. It was like checking your bank account, looking only at deposits and deciding you're wealthy. Then she began calling Joel's clients. One by one, she found their numbers and introduced herself as the person overseeing the transition. She had no legal authority to do this. She wasn't a lawyer. She didn't even understand what many of Joel's cases involved. But Carla believed confidence was the same as competence, and she had plenty of confidence. Most of Joel's clients, understandably concerned after receiving a call from their late attorney's mother, moved their cases to other firms within days. Carla was damaging the very revenue stream of the business she was trying to claim. It was like watching someone burn a house while arguing about its value. Then Spencer made his move. A week after Carla's visit to the office, he arrived at my house in Carla's Buick Enclave with 2 duffel bags, a PlayStation, and a large bag of barbecue chips. He walked to the door and announced he was moving into the guest room because, as he put it, Mom said it's basically ours now. He hadn't brought sheets, a pillow, or any work clothes, just the gaming system and snacks. I told him to leave. He refused. I called the Covington police. 2 officers arrived, confirmed the house was in Joel's name and that I was a surviving spouse, and escorted Spencer back to the car. He left the chips on my porch. I threw them away. That night, Carla called. Her voice rose to a sharp pitch as she accused me of being heartless and cruel, saying Joel would be ashamed of me for putting his brother out. I reminded her that Spencer lived in her guest house and already had a room there. She hung up. At the same time, the people close to me were urging me to take action. My mother drove up from Lexington that weekend, sat at my kitchen table, the same one where Carla had outlined her takeover, and said, "You have to fight this." My best friend Shannon called every night with the same advice. Hire a strong attorney and don't let Carla push you around. So I hired LRA Schmidt. She was recommended by one of Joel's colleagues, a German-American attorney in her mid-50s with silver-streaked hair and a calm, precise manner that made difficult situations feel manageable. LRA had handled estate disputes for 20 years. She reviewed Carla's filings in about 40 minutes and told me the case was winnable. The loan had no partnership agreement, no formal terms, and nothing in writing that gave Carla equity in the firm. Joel's will was clear and properly executed. LRA's assessment was simple. We fight, we win, and Carla leaves with nothing but a lesson in contract law. I told LRA I needed a few days to think. That night, after Tessa was asleep, I drove to Joel's office. It was almost 9 p.m. The building was dark except for the green exit signs in the stairwell. I unlocked his private office with the spare key I always carried and sat at his desk. It still smelled like him. Coffee and the sandalwood aftershave he'd used since college. I opened the bottom drawer, the deep one where he kept files he didn't want anyone else handling. Behind a stack of old case folders, I found a sealed manila envelope. My name was written on the front in Joel's handwriting, not Miriam Friedel, just Miriam, with a small heart beside it, like a note passed in school. I opened it. I read what was inside. Then I sat in that dark office for almost an hour without moving, without crying. For the first time since March 6, my thoughts were clear. The next morning, I called LRA. My voice sounded steady, even to me. I said, LRA, I've changed my mind. I don't want to fight. I want to give Carla everything she's asking for. Everything. LRA was silent for nearly 10 seconds. For someone who bills by the hour, that amount of silence was unusual. I need to explain what was in that envelope, because this is where the story changes. Without understanding what Joel did in the final months of his life, the rest won't make sense. 8 months before he died, Joel had been diagnosed with a serious heart condition. He had been experiencing shortness of breath during routine activities, occasional chest tightness, and a persistent fatigue that rest didn't resolve. He finally saw a cardiologist in Cincinnati at a major hospital system across the river. The diagnosis was serious, not immediately fatal, but progressive and requiring long-term management. Joel told me he had not informed his mother, his brother, or anyone else. Joel was a personal injury attorney. His entire career involved cases where lives fell apart because someone failed to plan, ignored risks, or assumed everything would work out. He wasn't going to leave his family exposed. So during those 8 months, while continuing to work, wear his suits, and discuss his cases at Sunday dinners with his mother, he was quietly putting things in order. The envelope contained 3 items. First, a handwritten letter dated 5 weeks before his death. It wasn't financial or legal. It was personal. He wrote about Tessa and how she called butterflies flutterbees, and how he never wanted to correct her. He wrote about our kitchen and the way the morning light came through the window above the sink and made everything look warm. He wrote about the day we met, when I was 22 and working at the front desk of Bernstein and Kellogg, the firm where he was a junior associate. He had asked me to lunch 4 times before I agreed because I had a rule about not dating lawyers, a rule that clearly didn't last. The final line read, "Don't let her take what matters. She can have the rest." There were no instructions or strategies, just trust. Joel knew I would understand once I saw the remaining items. Second, beneficiary confirmations. Joel had a life insurance policy worth $875,000. He had taken it out at age 30 when he started the firm, as required by the bank for his business loan. At the time, he was healthy and passed the medical exam without difficulty. In his final months, he updated the beneficiary, naming me, Miriam Friedel, as the sole recipient. Updating a beneficiary on an existing policy doesn't require a new medical exam, just a form and a signature. That $875,000 would be paid directly to me upon his death. It would never become part of the estate or go through probate. Carla couldn't access it. Even if she had known about it, which she didn't, she would have had no legal claim. Joel had done the same with his retirement accounts, a 401k worth about $152,000 and a Roth IRA with approximately $58,000. He updated both beneficiary designations to me. The same rule applied. A named beneficiary receives the funds directly, outside probate and outside the estate. That was another $210,000 Carla could not reach. To be clear, this wasn't a hidden loophole. This is exactly how life insurance and retirement accounts work in every state. Millions of families depend on this structure. Financial advisors routinely recommend reviewing beneficiary designations every year. It's not a trick. It's routine paperwork that many people delay or forget. Joel didn't forget. Third, the actual financial condition of Friedel and Associates. Joel had prepared a detailed handwritten summary in his precise legal script, listing every debt, liability, and risk inside what appeared to be a successful firm. This was the point where my perspective shifted from grieving spouse to careful decision maker. The firm billed $620,000 annually. That part was accurate. It was the number Joel mentioned at family dinners and the one Carla repeated confidently. But the reality behind that revenue was very different. There was $15,000 in outstanding vendor and overhead obligations, a pending malpractice settlement of $180,000 that Joel had already agreed to before his death, awaiting payment. $47,000 in unpaid payroll taxes. The IRS treats payroll taxes as trust fund taxes, meaning the responsible party can be held personally liable. Then there was the office lease, 34 months remaining at $4,200 per month. That's $142,800 in fixed rent for a space that couldn't simply be abandoned. The house was worth about $385,000, but Joel had taken a $220,000 home equity line of credit 18 months earlier to support the firm. Combined with the original mortgage balance of about $160,000, the total debt on the property was roughly $360,000. After closing costs, agent commissions, and transfer taxes, selling the house would likely produce no net value, possibly a loss. And Carla's $185,000 loan. She was an unsecured creditor. That meant she stood at the end of the payment line, behind the IRS, the malpractice claimant, vendors, the landlord, and every creditor with a formal agreement. By the time those obligations were addressed, if they could be addressed at all, there would be nothing left. The loan effectively lost its value the moment Joel died. She just didn't realize it yet. I sat in my apartment calculating everything on the back of a grocery receipt. My position, $1,085,000 in protected assets, clean funds, tax-advantaged, outside probate, already mine. Carla's position, approximately negative $520,000 after accounting for all liabilities against actual assets. The next day, Gail Horvath called me. Gail had been Joel's bookkeeper for 6 years. Carla had dismissed her the previous week. No notice, no severance, simply told her she was no longer needed. After years of keeping the firm's finances accurate to the dollar, Gail was both hurt and frustrated. She confirmed every figure in Joel's summary. She also shared something that made the situation even clearer. When Carla visited the office, she asked for revenue reports. Gail provided them. Carla reviewed them carefully, nodded, and left. She never asked about expenses. She never opened the liabilities file. She looked at a single column and concluded she was inheriting a profitable business. The next morning, I called LRA. I told her not to fight. I asked her to offer Carla everything, the house, the firm, every account within the estate. In return, I wanted one thing, full sole custody of Tessa, with no visitation for Carla. LRA asked me to come to her office. I brought Joel's envelope and placed everything on her desk, the beneficiary confirmations, the financial summary, the calculations. She reviewed the documents carefully, verified the numbers twice, and examined the insurance, retirement designations, and debt breakdown. Then LRA Schmidt, a lawyer with 20 years of estate experience, leaned back and laughed. Not a polite reaction, a genuine one. After a moment, she looked at me and said, "Joel was brilliant." Then she picked up her pen and began drafting the settlement. The following week, LRA contacted Axel Mendler with an offer that, on paper, looked like a complete surrender. Miriam Friedel would relinquish all claims to estate assets, the firm, the house, and every bank account in Joel's name. In exchange, she requested 2 conditions: full sole custody of Tessa with no visitation for Carla, and permanent withdrawal of the will contest. That was the entire proposal. Take the assets, leave the child. Axel, to his credit, was cautious. When someone agrees to everything without resistance, a careful attorney looks for risk. He called LRA and asked for time, specifically a full forensic review of the firm's finances. He told Carla he needed 2 weeks to properly examine the books. Carla refused. From her perspective, the decision seemed reasonable. For 7 years, she had seen Miriam as quiet, accommodating, and unlikely to challenge her. No matter how often Carla minimized her or questioned her choices, Miriam had remained polite and restrained. In Carla's view, this was simply more of the same, Miriam giving in. And when you believe you're holding a winning position and the other party is ready to walk away, you don't pause to recheck your numbers. You accept. She told Axel, "I've seen the revenue, $620,000 a year. My son built that with my money. Get the papers signed before she changes her mind." Axel objected strongly. He prepared a formal advisory letter, 2 single-spaced pages, stating that due diligence on the firm's financial condition was incomplete and recommending that Carla wait for a full audit before accepting any transfer of both assets and liabilities. This was standard legal procedure. Attorneys do this to protect themselves, and Axel was protecting his position carefully. Carla read the letter, signed the waiver at the bottom, acknowledging she was proceeding against her attorney's advice, and told Axel to schedule the signing. There was one additional question. Axel asked LRA directly whether there were any non-estate assets they should know about, life insurance policies or retirement accounts with named beneficiaries. LRA responded appropriately. Non-estate assets fall outside the scope of an estate settlement, and her client had no legal obligation to disclose them. Carla heard this through Axel and dismissed it. Joel had never mentioned life insurance to her. She assumed he didn't have any. In her view, he was 36 and healthy. Young men don't usually think about life insurance, except Joel did. A bank had required the policy 6 years earlier, and Joel was the type of person who continued paying premiums on time, even when other parts of his life were under pressure. While Carla was signing waivers and disregarding her attorney's recommendations, I was quietly preparing my new life. The insurance company processed the claim in just under 3 weeks. $875,000 was deposited directly into my personal checking account at a credit union in Florence, Kentucky, an account I had opened specifically for this purpose, with no connection to Joel's accounts or the estate. I also completed the rollover of Joel's retirement funds, $152,000 from his 401k and $58,000 from his Roth IRA, into accounts in my name alone. I began moving out of the house gradually. Nothing dramatic, just a few boxes at a time. Tessa's clothes and toys first, then my books, documents, and photo albums. I found a 2-bedroom apartment in Florence, about 20 minutes south of Covington. It was clean, safe, and located in a good school district. The first and last month's rent totaled $1,800. I paid it from my account without hesitation. Meanwhile, Spencer was attempting to manage the firm. Carla had sent him there to oversee operations during the legal transition. In practice, he sat in Joel's chair, turned it in circles, and tried to understand the phone system. He called a process server a delivery driver and asked a paralegal to explain what a retainer agreement was. On his third day, Carla had him go to the bank and add himself as a co-signer on the firm's operating account so he could handle daily expenses. Spencer signed every document presented to him without reading. He didn't realize he was accepting joint responsibility for any obligations tied to that account. Reading details had never been his strength. My mother came up from Lexington one more time. She sat across from me at my new kitchen table, a small IKEA table I had assembled myself, which honestly felt like a greater achievement than many things I had done before, and asked if I was sure about giving up Joel's house and his life's work. I wanted to show her everything. I wanted to open my banking app and let her see the balance. But I couldn't. Not until the papers were signed, and there was no risk that information might reach Carla through the small-town network where news travels quickly between families. So I told her, trust me, it's going to be okay. She didn't fully believe it, but she hugged me anyway. The signing was scheduled for a Tuesday in late June. The night before, I laid out Tessa's daycare clothes, packed my bag with the apartment lease and a folder of bank statements showing $1,085,000 in protected assets, and set my alarm for 6:30. I went to bed and fell asleep within 5 minutes, the first time that had happened since March 6. Axel Mendler's office was on the 3rd floor of a brick building on Pike Street in downtown Covington. The conference room had beige walls, industrial carpet, and a coffee machine that produced something warm and brown, though only loosely related to coffee. I arrived at 9:15 with LRA. We sat on the left side of the table and waited. Carla entered at 9:20 with Spencer and Axel. She was dressed formally, with full makeup, gold earrings, and a cream silk blouse. Spencer wore a new navy blazer. The price tag was still tucked inside the collar, visible against the back of his neck. The documents were straightforward. I, Miriam Friedel, transferred all claims to Joel Friedel's estate assets, including the law practice Friedel and Associates, the residential property, and all associated financial accounts, to Carla Friedel, who accepted both the assets and all related liabilities. In exchange, Carla relinquished any custody claims regarding Tessa, granting me full sole custody with no visitation rights for either Carla or Spencer. Before I signed, LRA made a brief statement for the record, confirming that I was signing voluntarily and that the opposing party had reviewed and accepted the estate, inclusive of all disclosed liabilities. Axel confirmed. Carla did not look up. She was already reaching for her pen. I signed. Carla signed. Spencer sat smiling, as if he had just stepped into a major leadership role. The entire process took 8 minutes. As I stood to leave, Carla made one final comment. She said she hoped I would learn to stand on my own without relying on a Fredo name. Spencer nodded in agreement. I picked up my bag, left the office, collected Tessa from daycare at 3:15, and drove to our apartment. I made her boxed macaroni and cheese, the dinosaur shapes she insisted tasted better than regular pasta. We watched cartoons until evening. She fell asleep on the couch, and I carried her to bed. Then I sat on the kitchen floor with my back against the cabinets and took a long breath. It was the calmest evening I had experienced since Joel's death. 3 weeks later, Carla Fredell walked into Fredell & Associates as its legal owner and began running the business. I wasn't there, but in a place like Covington, information travels. Gail still had friends at the office, and some details came directly from Carla during a later phone call. On the first day, Carla opened a stack of mail that had been sitting on Joel's desk, envelopes she had passed repeatedly without opening. The third letter was from the Internal Revenue Service. Notice of $47,000 in unpaid payroll taxes, with penalties continuing to accumulate. On the third day, she received a call from a Cincinnati attorney representing the plaintiff in a malpractice case against Joel. The settlement, agreed to before his death, was $180,000. Payment was overdue. The attorney was polite but firm. On day 5, the building landlord called about the office lease. There were 34 months remaining. Carla had to sign a personal guarantee to take the lease in her own name or vacate within 60 days. Carla signed the guarantee without hesitation. In her view, the firm generated $620,000 a year, and $1,400 a month in rent seemed manageable. In doing so, she personally committed to $142,800 in future payments. By day 8, Carla tried to access Joel's QuickBooks file. Without Gail Horvath, the records were confusing. 6 years of carefully categorized entries made sense to Gail, but not to anyone else. Carla hired a temporary accountant from a staffing agency. The accountant spent 4 hours reviewing the files, then informed Carla there were more than $115,000 in unpaid vendor invoices, some dating back 14 months. On day 10, Gail filed a formal employment claim for termination without notice or severance after 6 years of service. The estimated claim was $20,000. That evening, Carla called Axel Mendler. I don't know the exact details of the conversation, but Axel reviewed his records and read back the advisory letter he had previously provided. He reminded her that he had recommended a full audit and that she had declined. He also reminded her that she had signed a waiver. The documentation was clear. Later, Carla called me. I saw her name on my phone as it rang in the dark. I let it ring, turned the phone face down, and went back to sleep. Carla then hired a new attorney, Betsy Polk from a Cincinnati firm, someone independent from the original case. Carla explained that she had been misled and pressured into accepting a worthless estate by her daughter-in-law. Betsy reviewed everything: the settlement agreement, the signed waiver, Axel's advisory letter, and the estate disclosures prepared by LRA before the signing. Every liability had been listed. Every debt was documented. Nothing had been hidden or misrepresented. I had not provided false information. I had simply not disclosed assets that were legally mine and outside the estate. After reviewing the case, Betsy gave Carla a direct assessment. Carla had competent legal representation. She had been advised to wait for a full audit. She refused. She signed voluntarily. The agreement was mutual and properly documented. There was no fraud and no legal basis to challenge the settlement. The conclusion was clear. This was not a legal issue. It was an expensive lesson. Carla then attempted to sell the house. Her realtor calculated the numbers and explained that after paying the mortgage, the home equity line, closing costs, and commission, Carla would need to bring approximately $11,000 to closing. The property was not an asset. It was a liability. The IRS continued adding penalties on the unpaid payroll taxes. Carla began using her personal savings, money she had built over decades from her dry cleaning businesses. She sold her Burlington location first, then the Erlanger store. Two businesses were gone within 2 months, and the firm's total obligations were still far from covered. Spencer, who had been acting as managing partner for 19 days, decided to step away. He attempted to remove himself as a co-signer from the firm's operating account. The bank informed him that his signature created joint responsibility for certain obligations processed through that account, including vendor payment arrangements Carla had established after the transfer. Spencer hired his own attorney and filed a claim against his mother, alleging she had pressured him into signing documents he did not understand. The case did not succeed. He had signed voluntarily as an adult, with no evidence of coercion. However, the lawsuit itself, Spencer Friedel versus Carla Friedel, was formally filed in Kenton County. The same mother and son who had once stood together planning their takeover were now represented by separate attorneys in a dispute against each other. The last time Carla called me, I answered. She was emotional and said she was losing everything. She said she hadn't understood the situation and asked for help. I listened without interrupting. When she finished, I reminded her of the conversation in my kitchen, when she had said she wanted everything except my daughter. She had asked for the house, the firm, and every dollar. I told her she had received exactly what she requested. Then I ended the call and returned to helping Tessa with a craft project. She was gluing macaroni onto paper to make a picture of a horse and needed extra pieces for the mane. That evening, after Tessa went to bed, I sat at my small IKEA table, the one I had assembled myself, and opened my laptop. I completed an application for a paralegal certification program at Gateway Community College. Tuition was $4,200 per semester. My account balance was $1,085,000. The program was affordable. On my nightstand, in a simple black frame, was Joel's letter. Each night, I read the final line before turning off the light. Don't let her take what matters. She can have the rest. Thank you for staying through this story. If it meant something to you, there's another one on your screen now, and it may be even more compelling. Click it, and I'll see you there.